telling him everything arises by contract and agreement, and he keeps believing that common law is not a contract or an agreement.
Well, basically common law arises out of custom and usages. Customs are agreements, whether written or otherwise. And usages arise from the customs, which are the agreements to be able to treat with one another in relationship to society or otherwise, multiple societies. So the common law was usually ruled by the customs and usages, which are agreements to treat with one another or foreigners. And in respect to that, that's how the difference between common law of the land and the common law of the sea develops. And those were agreements when you're off the land, how you would treat, and those were agreements when you're on the land, how you would treat. But you cannot say it's not contract, because otherwise, how would you treat with one another to acquire services and goods from any society or each other to perform according to the obligation to acquire such services and goods? This is nothing more than contract law, period.
Can I stop you there a second and address this issue about trespass?
First of all, they're making an assumption that they have permission to do that. That assumption to do that is only going to be questioned when there is an agreement either to disallow it or to allow it. And it is allowed in the interest of peace, but that still deals with agreement. And if there is no agreement to allow it or to end it, trespass arises under law of custom and usages. Some may refer to it as common law, some may refer to it as statutory, some may refer to it however they wish, but it is still contract agreement between one and another, or how many others that may be involved. And breaking the closure without permission, that is trespass, because they don't have permission to do it. They don't have an agreement. Now, if you violate that agreement or that contract to keep the peace, you have a violation of the peace, and that ends up in a violation of contract. You do not have permission to be here, or whatever. But it is still an agreement. Nothing has ever arisen otherwise, unless you're dealing with a state of nature where chaos rules.
I've tried to convey this in any number of ways. Even what you're saying with common law, customs and usages were developed by agreements.
So what does the law of the land mean?
Well, the law of the land would be the customs and usages that are
based on what?
Well, the agreement of the people within the society.
And many centuries ago, they would like to say it's unwritten, because the common people did not know how to write. So these customs and usages came out of such eras. Let's take, for instance, the common law of England, which they openly say they have an unwritten constitution, but, believe me, they don't. They have a written constitution. They just call them different names, like charters, like the Great Charter, from the king recognizing the rights of the people. It's an agreement with the king, with the subjects. No longer do this, or I will do this, and so forth. So they have a written constitution or charter or whatever you want to call it, but it is a contract. And if he violates it, then there's actionable cause related to the law or to the agreement. So the law is the agreement. That's as simple as it gets.
You can't breach the peace unless somebody has agreed over what peace is or is not.
That's a contract.
Exactly. And you and I talked about this. All these different venues of law are nothing more than a way to divide how people are going to treat contracts.
Yeah, and I disagree. It leads to chaos.
That's my whole point about this. Can't you read the document?
And even the Constitution.
Which Constitution? The ones in Rome or the ones in England or the ones...
As most people know here, the U.S.
Oh, yeah, that Constitution.
You understand under Article 1, Section 10, it says, and they shall not impair the obligations of contract. So do they not recognize that contracts are superior?
Not only that, they would be superior to custom and usage. Because you and I could sit down here and between the parties actually agree on a contract which would be a variation of agreement of the custom and usage.
That's what led them to adopt Article 5, Section 116. My whole point is, for people who are locked into semantics, they must look at the facts and the reasoning behind what makes a society. It is nothing more than its customs and usages, which have been developed for billions of years or 2 minutes. It doesn't matter. It's all by agreement. You're going to act this way, I'm going to act this way. And we have to set up the institutions when there's a breach to how we've agreed to act. And these are called forums, courts, and agencies, which are used for for arbitration in relationship to settling matters that may arise in relationship to such breaches or otherwise, to keep the agreement, or otherwise known as to keep the peace. The peace is the agreement.
Can we get into another point about what you just said about the Constitution?
Sure.
I keep hearing about all these amendments.
Right.
And, of course, I keep looking at the contract.
Right.
Being that it was we the people of the United States.
The opposite term would be of. People of. The verb would be they did something for.
Yeah, they did something for the United States of America.
Correct. They became constitutors under Article 6.
Clause 1.
Exactly. Assumed the debt that the former United States of America had become indebted to. Now the Treaty of Peace arose. They went and negotiated to pay the debt for the United States of America. That is, the individuals who were the plenipotentiaries representing the United States in Congress assembled. It did not say the United States of America in Congress assembled. It said plenipotentiaries were representing the United States in Congress assembled. And so thereby, once the treaty was signed, they had to come back and create this document, which became the Constitution, which they agreed to service the debt.
Going back to the amendments and who those amendments apply to.
The signatories and their posterity.
Exactly. So they have the right to free speech. They have a right to this. It has nothing to do with anyone else.
Well, if the Constitution was still applicable, I would agree with that. But I don't even think the Constitution is still applicable because Congress has already said it hadn't been operating out for over 70 years.
Well, they keep wanting to regurgitate this document as if they had some standing to be able to regurgitate
They're not party to it. I mean, Barron versus Baltimore says it. Paddleford versus Savannah says they're not party to it. They can't take two witnesses such as that to prove the point. I don't know what to tell you. The 9 cases I gave you in reference to the standing of the parties to be able to state a claim prove that they don't have any ability there too. And like I said, the show must go on in relationship to servicing the debt. And even though the parties who are signatory and their posterity have learned to shift the debt to others who have no standing to state a claim according to the 14th Amendment, okay, which shifted the burden to accept service the debt with the only right to vote. It's very interesting that they had to adopt an amendment to vote for people who already assumably had it. So anyway, people just want to see what they want to see, brother. That's all there is to it. So they get the right to collect the debt on their backs to give them the right to vote, and their vote doesn't count because they're under limitations, restrictions, or reservations in relationship to exercising that right to vote. By the way, they never changed the Constitution in respect to who really puts the president or the vice president in office, the collegiate college or whatever. So the delegates still do it, even though it's a hidden sense. The Senate is still responsible for doing what it says under Article 12. But that's besides the point. So my point is, if you cannot see the fact that you don't have standing, there's nothing that you can change. You've been indoctrinated. You're going to believe it to your own destruction. You're not going to change anything. Those people who believe they can change something that sits and they have no standing to state a claim, well, I don't know what to tell you. Can I use the appropriate words, deluded?
Well, that's what you said the other day. If you can't accept the fact that you were lied to from the time you were born.
Pride stands in the way, and boy, they pump that up every day for them, don't they?
Well, I'm hearing about people going to take back counties.
Oh, yeah, right.
Take back as if they owned it. They don't own it.
No, they don't. Ownership is in the state. Where does that? Where haven't they read that?
Well, that's what it says.
Record?
Yes, Senate Resolution number 62. All ownership is in the state. Of course, they're going to say that that's all done by a bunch of criminals.
Well, I suppose they have standing to be able to state that when the obvious facts and relationship thereto by contract language states they're not signatory, nor are they one of the posterities in relationship to the signatory authority creating such, gives them such standing to state such claims.
It's so succinct in the Paddleford case. Constitution is a compact, that's true. And it's also true you're not a party to it. Even in the Treaty of Paris, when they acknowledged the states as being sovereign, it was the states in their collective capacity.
Oh, yeah, absolutely.
Not in their individual capacity.
They don't recognize individual sovereignty.
Well, not only that, when I looked up that review that the 3-judge panel did of the Dones versus Pajalo case way back in 1792, they specifically said in there that all private property ownership was in the states, and all public property ownership was in the United States, or in the hands of the United States Congress. So if all private property ownership was in the state, what's that got to do with the individual?
What right do they have to talk about the county?
Right, because the county's owned by the state.
I cannot help the misrepresentation and fraud that's heard in the centers of education. But They did it because they wanted to shift the burden of the debt. They want to service the debt, but they don't want to have the liability of paying the debt. So that's what they did to do it. Do you blame them?
Well, no, if the people were dumb enough to accept it.
You got it, brother.
That's why I said in that presentation I did, the 90 minutes, no one wants to hear that part. I said, look, if you want to accept this liability of the constitutors and make yourself an agent of the constitutors or a constitutor yourself, then pay the debt. Bears have no rights, none.
Because in there in the thing that says what? You will not question the debt, right?
Exactly.
Because you are not recognizing the fact that you cannot conceptualize any other situation to get out of it because you're too susceptible to indoctrination and you've not proved yourself worthy to come out. And if you're not willing to come out and present your standing in relationship to assuming your equal station among the powers of the earth to which the laws of nature and nature's creator entitle you, then be its slave and be happy with it and stop complaining.
When they went out and borrowed the florins and rose up their military, and then the military rebelled against them when they didn't get paid.
Right.
Well, if those men had pledged their lives, fortunes, and sacred honor, they wouldn't have been rebelling.
No, that's correct. They'd have been out there fighting harder, right?
Exactly. Instead of worrying about what their paycheck was as a mercenary army.
You got it. You said it. That's why they went into hiding in Annapolis and did something else. You know what they did? They went and treated with the king to get a treaty of peace and say, okay, apparently, the incompetence and the insanity is running amok here, and we've got to find a way to control the incompetence. Now we have to sue for peace. That's what we're trying to do. We're trying to create order in a peaceful way for ourselves. We're not trying to do it for anybody else. We have no desire to be in collusion with incompetence. You do realize that, right?
That's why it says for those men of goodwill.
What's the sign of being a man of goodwill?
You're pledging to assume his separate and equal station among the powers of the earth.
Nothing else. People don't realize this is contract. Somebody at one time wrote it in stone because they were so brain dead. Okay, everything has been verbal up to this point. Apparently, I have to put it in stone for you guys to understand this is an agreement. This is a contract. And they were required to read that law all the time, correct? To remind them?
Yeah, they had to wear it on their forehead.
Better believe it. If they can't accept 6,000 years of history, it really astonishes me. You've got people running around a business who think they know what business is.
Right.
They think they own something. I can prove fact that you don't have nothing. You don't have diddly squat unless you pledge to do whatever to create something to be able to have standing to state a claim in relationship to what you believe you own. But they parade around as if they're competent. But we know those without standing are controlled by such policies and procedures and regulations and statutes and codes because they're incompetent. That's why they have to have corporations. Because to do business, the state has to give you permission because they know you're incompetent, and they've got to have regulations to control you when you do stupid stuff. Because you haven't pledged to do anything otherwise than just do stupid stuff by coming to them and getting permission when you already have the power at your fingers to do what is necessary to acquire standing.
Oh, I just got an email about Leroy Schweitzer's video. Leroy was with you, right?
Yes.
And Leroy didn't get it either, did he?
No, he didn't. He just didn't get it. And it's not like saying, I was doing the same thing, brother. I was under that program, too. But as time waned on around 97, 98, I was beginning to come out of the program because I was seeing what was going on. I had to admit, because of the facts that were going on around me, that I had been lied to. That was the only answer. I had to give up my pride and say to myself, well, if I've been lied to, I've been willingly lied to, I've been duped by role models, teachers, preachers, patriots, whatever the crap is out there spewing this garbage. I have been lied to. At that moment did I begin to see the light. So if their pride is too great that they cannot admit that they have been lied to, they will never acquire standing to be able to state a claim for which relief can be granted, and they will always be subject to outside control. People have got to realize that they've been lied to. That's the whole crux of the matter, brother. If they can't read the facts of which we put out in the book some time ago, which you've extrapolated and used in respect to other things, they're not going to see anything else. They can't even accept what's put before them. If they're not willing to do the research themselves, what is it about these people that they don't forget that they're required to test all things? And testing all things means you must do the research. And if you're not willing to look at the research and test the research, then you're not, one, willing to accept responsibility. And you cannot accept responsibility unless you're willing to test all things. So stop complaining and go back to being a slave.
Like I wrote in that document on the historical perspective of self-determination. Every nation on this planet exists because of the right of self-determination.
Absolutely.
And when men had disagreement and they couldn't get redress within the construct that they were living in, then they decided, well, I guess it's time to form a new construct. This whole formation of the new construct is nothing more than asset protection. But that's the reason why these so-called founding fathers, who aren't the fathers of them that they think they are, that's the reason why they did it. They did it to protect their assets. And they were
safeguard their liberties.
And their property.
And the property was what? Their equal station. It's a wonderful conversation on what the hell common law is. You know, common to those who create anything, not to those who presume to trespass.
Yeah, and then we got to get into an argument about which common law we're talking about now.
Oh, I don't want to go there, but because common law, once again, I don't even have to get in an argument. Show me the contract. Because it's common amongst those who are signatory there, too. The signature is attached to it unless you can, prove that you're, in direct line relationships there, too, for the benefit thereof. You ain't got squat.